You've seen the lawyers here be polite to each other. We try to assist each other in getting the evidence in front of you. I don't want that to be confused for a second with how much these plaintiffs have had to endure.
Good afternoon, everybody. Good afternoon. Just turn my microphone on here. So Mr. Kemp covered a lot of the ground. I should be able to be fairly brief. I'm going to cover with you the carrier's story, what they went through, and then I'll talk to you about why all 5 of the children in this case need future neuropsychological care. But before I get to the substance of the matter, I want to first take a second to thank you all for your time, your service as jurors. On behalf of the carrier family, it means the world for them, what you're doing here. And so, the first day I stood up in open argument, I talked to you about the carrier family. I took you through their story, and now you've heard firsthand everything that they've gone through. I'm going to touch on some of the high points for you now. Back in early November, Hera Carrier got sick. You recall she was vomiting, she was throwing up, and her parents, because she was throwing up, kept giving her more and more real water. Mr. Carrier talked to you about that. Let's play that clip, please, Shane.
And she just wouldn't stop. Unfortunately, what you say to yourself a lot of the time is, I was really concerned about her getting dehydrated because it happened before, and then we had to bring her into the emergency room. So my wife and I just kept giving her more water, and giving her more water, and giving her more water.
That's a memory that Mr. Carrier has. It's a vivid one. That's past damages that Mr. Kemp was talking to you about. But he also shared with you how this stays with him. He talked to you about how he blames himself. Can we see that clip now, Shane?
You didn't blame yourself. I can't yet. I was the one that brought it into the home. Whenever she gets sick, you always kind of blame yourself because we poisoned her that night. Could have grabbed Gatorade, right? Could have grabbed anything else, but grab the thing that you think is the safest in your home. So, yeah, I blame myself a lot.
It's a difficult memory of the past, but that's something he carries with him. It's something he still thinks about. It's something he'll continue to think about. And that goes to future pain, suffering, and anguish. These are photographs of Hera in the hospital. You've seen these. Before Hera went to the hospital, you recall Mr. and Mrs. Carrier both talked to you about how she was throwing up over and over again until she couldn't throw up anymore, and then she dry heaved over and over again, and then she slept for hours and hours. They couldn't wake her up. And finally they got a little worried and said, well, we better do something. Let's try to wake her up, and she wouldn't. Mr. Carrier talked to you about lifting her up and her body being completely limp. And that's when they realized she needs to get to the hospital right away. The Carriers had every reason to be concerned because when they got to the hospital, they did a glucose test. Next. Hera's glucose level at Sutherland Hospital was 19. Dr. Hudson referred back to this level. He thought it was 20. It was actually 19. It was critically low. And what Dr. Hudson talked to us about with this level is that people with a glucose level of 19 or 20, they can go into a coma and die. That's how serious this was. Hera was very close to death. You've seen more records of Hera's hospitalization. I'm going to just touch on a few of the key points. Mrs. Carrier talked to you about medicine or drug that they gave Hera at Summerlin to get her to throw up. They were concerned she might have consumed something toxic, which is true, but they thought they might be able to expel it from her system. So she talked to you about getting that substance that made her vomit. She vomiting blood in the hospital and the nurse holding her hair back. She had to undergo lumbar puncture. Just like what Mr. Morales shared with you, Mrs. Carrier talked about that too. She wasn't allowed to stay in the room because they were concerned her being there may cause Hera to flinch, which could result in her being paralyzed. Hera also had acute bleeding. You see that's over there on the right and underlined in red. Mr. Kemp talked to you about the INR levels. It prevents clotting. Hera had acute bleeding. She had to get FFP, fresh frozen plasma. That's transfusions that she had to undergo. You've heard a lot about the AST and ALT levels. Here, when Hera first appeared at Summerlin, these are elevated, but as you know, they got much, much higher. Mrs. Carrier talked to you about when she first got really scared, so when the doctor came to her, and she could see the fear in the doctor's eyes. Because the doctor knew that her levels didn't go down like they thought they would, but in fact, they had doubled. Go to the next slide, please. Back. The top, later at Summerlin on November 11th, Hera's ALT 419, her AST up over 3,700. But even more concerning, why that doctor at Summerlin must have been so scared. The INR level is over 8.7, critical. Dr. Hudson talked to us about the INR. What did he say about patients with an INR of 8? Those patients usually don't recover. Hera, again, very close to death, gravely, gravely ill. So ill that she had to be sent by life flight to Primary Children's Hospital. You saw the transfer form, the authorization that was explained to all the parents. You heard about how this was a matter of life and death. And when Hera got to Primary Children's Hospital, her condition hadn't improved, it was worse. Labs upon arrival. This is the big reading. The AST level over 12,000. You've heard about this already. I won't belabor the point, but it's astoundingly high. It's higher than most doctors ever see in their career. But as you learn throughout this case, the liver doesn't just fail in isolation, it impacts the other organs. So as her liver function decreased, her brain swelling increased. Hera was swelling so bad in the brain, she was at risk of cerebral edema. She had PICU level care for monitoring for encephalopathy due to her initial risk of acute decompensation. The doctors were worried that Hera was going to suffer systemic organ failure. Very, very serious illness. The hospitalization for Hera was difficult, it was traumatic. It was so traumatic that the intensive care doctors at Primary Children's Hospital, these doctors see some of the sickest kids in the country, noted on how scared Hera was. Flat effect and blank stare, seemed overwhelmed by the large crowd in the room. Multiple occasions where child life therapy service was sent to the Carrier room. And you heard about this in detail from Mrs. Carrier. She was there with Hera every day and every night for 12 days. She talked to you about what the hospitalization was like. Let's play that clip for you now.
How did it feel to be in the hospital with your 5-year-old daughter? She's suffering acute liver failure. And even some of the best doctors in the country can't tell you why.
It's a parent's worst nightmare. If you're a parent or a grandparent, you're helpless. You know, you want to protect them. And you can't, because you don't know what's going on.
Did anybody at the hospital ever tell you that Hera was going to be okay?
Nope.
What was the hospitalization like for Hera? What were some of the things that she had to go through?
Horrible. I think a lot of the other parents may have touched base, but the blood draws are excruciating. Horrible. I mean, this kid has probably been pricked 60 times. They were monitoring her blood, so every 2 to 3 hours they had to come in and pull blood. And this kid had so much anxiety the minute that door would swing open. Are they coming for blood? And she was worried and she was scared. And the problem was the veins were collapsing. They literally were rolling and they couldn't find them. So once they had collapsed in her arms, they had to go into her groin, and they had to go into her feet, and they had to go into her hands, which there's not a lot of fat here, and if you've ever had like an IV, it's really painful when you can't find veins and you stick it. And there was multiple nurses that would come in and couldn't get it, so we would get hurt 4 or 5 times before we could even get the vein. And they had to get the vein finder. There was a device that would come in and try to highlight all over her skin, where they could try to locate a vein. She's traumatized by this. She was absolutely traumatized by getting blood work done. It's basically became a permanent scar for her. To go through that, we are still doing that right now.
Vivid description of the past pain, suffering, and anguish Hera experienced and her parents experienced with her, as well as a mention of how it continues to impact their lives going forward. It's their worst nightmare. Next slide, please. This is another thing I want to touch on. This is the report from Hera's liver biopsy. And you recall the takeaway from this biopsy, it's down here at the bottom of the comment. The biopsy informed the doctors at Primary Children's Hospital that her liver injury was secondary to a drug or toxin. They didn't know what it was, but they were able to tell from what they saw in the liver that that was the cause. That was important. But this biopsy result was not normal by any means. The final diagnosis at the top, extensive hepatocyte steatosis. Steatosis is the fatty part of the fatty liver condition that Dr. Hudson talked to you about. That is abnormal for anyone. It's especially abnormal for a child. Mrs. Carrier talked to you about the conversation she had with Dr. Guthrie about this abnormal result. Go ahead, Sean.
What is that?
The first thing was they told us she had fatty liver. I didn't know what that meant. I was like, okay. And I said, she likes French fries. You know, she does eat those, part of this nightmare. He's like, no. I was like, not even close. He said she's got a fatty liver of a 300 pound person. That's how bad her liver is.
Liver of a 300-pound adult in a 5-year-old child. Real Water wants you to believe that this biopsy result is normal. It's anything but normal. Next slide, please. As Mr. Kemp touched on already, Dr. Hudson has testified and shown you that all of the children in this case have suffered bridging fibrosis as a result of consuming real water. And the word Dr. Hudson used that you saw in the transcripts and the clips that Mr. Kemp played for you, he described it as irreversible. You can't turn back the clock and repair the liver. It is a permanent injury. Hera and the other children in this case will carry that injury with them the rest of their lives, and it will impact them in the future. So let's take a look at the verdict form again, just briefly. This is what Mr. Kemp explained to you. Past physical and mental pain, suffering, anguish, disability, permanent injury, loss of enjoyment of life, and the same things in the future. And just as Mr. Kemp explained, we suggest that you should award all 5 of the children the same amount. $5 million in past, $5 million in future. Next slide, please. The parent plaintiffs also have a claim. These are the parents and their past mental anguish related to having to undergo this terrible experience with their children. The anguish they suffered with their kids in the hospital and seeing them go through acute liver failure. In the past, for the hospitalization and all those things that you've heard about, as well as in the future for how it continues to impact their lives and the need for future neuropsychological care, which I'll get to in a minute. Just as we did with the minor plaintiffs, with the children, we suggest awarding all of the parents the same amount. Everybody's story here is terrible. It's heartbreaking. And personally, I don't know how you can compare one to the other. You're welcome to do that. We would suggest $1 million for each parent in the past, $1 million for each of the 5 parents in the future. And just as Mr. Kemp told you, if you feel the award should be larger than that, you're welcome to do so, but this is a suggestion that we think is fair, both as to the minor children and the parents. So I've covered with you now the physical components of all this and the acute liver failure that Hera and the other children suffered. But as I mentioned earlier, the liver doesn't fail in a vacuum. It impacts the other organs, and you've already heard that it impacts the brain. And because it's impacted the brains of these children, there's a need for future neuropsychological care. So let's talk about that now. You recall this is our neuropsychological expert, Dr. Sands. Dr. Sands is a pediatric neuropsychologist. He works at a cancer center in New York. He's also a professor that teaches other neuropsychologists. He's been treating pediatric patients, and specifically kids who have survived cancer or other life-threatening illnesses. He's been doing it for over 25 years. This isn't somebody who just got licensed a year or two ago. This is somebody who spent the majority of his life treating kids just like the kids here. Dr. Sands, as you heard, he reviewed all of the medical charts. He spoke with all the parents. He reviewed their testimony. He reviewed all the scientific literature. And what he told you based on all that work, as well as his experience, his professional experience, that all of the children here need this future neuropsychological care and monitoring. So let's just touch on briefly some of the things that Dr. Sands relied on to reach that conclusion. You may recall this article. This is an article about liver fibrosis. They did this huge study in the United Kingdom, over 105,000 participants, all of whom had liver fibrosis, and they did tests on them to see how they're doing. And what they found was that liver fibrosis was associated with worse performance on executive function tests. Liver fibrosis was associated with lower hippocampal and total brain volumes. Hippocampal is the bottom part of the brain. A very important study given the amount of people that participated in and how much data they were able to pull from. And as Dr. Sands explained to you, this was a study about adults. It wasn't children. This was adults 40s, 50s, 60s years old. Real water doesn't present anything to you that says this study's wrong, that the data's no good or they messed it up. What they do is they try to dodge the impact of this study by saying, oh, well, this is adults. These are kids, so it's apples and oranges. Remember you heard that phrase a couple times? It's apples and oranges. But our experts say otherwise. There's no reason the liver of a child should be considered different than an adult. Dr. Hudson talked about this. Down here at the bottom, when somebody has liver failure or advanced liver disease, a kid's liver is the same as an adult's. So there's no reason why a child with fibrosis wouldn't suffer the same impacts as the adults in that study. Dr. Sands addressed it too. This was the study he found and thought was meaningful. He talked to you about why, even though it was an adult study, it's important here. Yeah, Dr. Sands.
I just want to also say to you that these are adults, and we're talking today about children, but my mind is that if adults whose brains are fairly developed and pretty mostly developed are significantly worse on those key factors, can you imagine what a 3-year-old, a 4-year-old, a 5-year-old who went through and has similar fibrosis, they're going to be in the same boat, if not worse. So the fact that it's adult doesn't, in my mind, discount it. It makes it even more serious for the children.
You heard that? There may be a difference between adults and kids. The significance of the difference is that for a child with a developing brain, the impact is even worse. We would expect the symptoms to be even more profound in developing children. I'll talk to you about a couple other studies briefly. This is the study, Neurodevelopmental Outcomes in Children with Liver Diseases. It's another study Dr. Sands mentioned. This study found that children with liver diseases are at an increased risk of deficits in all neurodevelopmental domains, cognitive, behavioral, motor outcome. This article also mentioned a generally accepted principle in neuropsychology, which is that when a child suffers severe disease, hospitalization, surgery during early childhood, it's thought to interfere with the healthy development of children's central nervous systems. Dr. Sands told you that. Dr. Bailey agreed that that's generally accepted. We would expect that this is going to have a lasting impact on the neurodevelopment of these children here. Next. This is the article, Neuropsychological Functioning and Health-Related Quality of Life. This was the one article that you recall we called out the author's name, Dr. Lisa Sorensen. And we did that because Dr. Sorensen has written more articles and studies on this area, what happens to children's neurodevelopment after suffering liver failure. She's written about it more than anyone else. Dr. Bailey agreed with that too. And this is Dr. Sorensen's own study on children, pediatric acute liver failure, all children who suffered that condition, just like the children here. And what she found is that long-term survivors can expect greater than expected impairments in motor skills, attention, executive function, and health-related quality of life. The literature makes it very clear that these children are going to experience difficulties as they develop. That's why they need the care and monitoring in the future. Real Water has no meaningful response to these studies other than to just say, it's not a study about specific kids who drank hydrazine and suffered liver failure, and since it's not completely on point, everybody should just disregard it. The weight of the evidence, more likely than not, tells you that these children are going to suffer these types of issues as they grow older. Next slide, please. This is Dr. Bailey. She was here, and she's Real Water's neuropsychology expert. And I understand her position to be a couple of things. First, Dr. Bailey agrees that the parents in this case are entitled to future neuropsychological care, but she doesn't agree that the kids get the same thing. You don't have a decision to make as to the parents' future neuropsychological care. It's been stipulated to. It's not an issue. The kids' future care is an issue because Dr. Bailey and Real Water don't believe the children should have that. And how does that strike you, just from a common sense perspective? That the parents get future care, but not the children who suffered the acute liver failure, who suffered the encephalopathy, who were poked and prodded in the hospital, who are still developing. They don't get future care, but the parents can. I would submit to you that just at a common sense stage, it's illogical. I think it's absurd. Basis for this opinion that Dr. Bailey provided is that she said the children here are thriving. That was the word that she used in her testimony. And you heard the basis for this type of an opinion. Real Water's counsel has mentioned it before in the cross-examinations of the parents, where you bring up extracurricular activities and things like that that the children are engaged in, playing softball, gymnastics, things like that. And because they're able to do those things, that they must be completely fine. That's just not the case. Dr. Sands addressed this. Can we play that, please?
Dr. Sands, Mr. Odou referenced a few, sounds like good things these children are doing. Parents playing softball. Senator Morales in pre-K wants to be a YouTuber. London and Lyric maybe doing gymnastics or soccer. Chris runs in some form of educational program. The fact that these children are doing these good things, does that mean your opinions are wrong?
Absolutely not.
Does it mean they're not at risk?
No, it means they are at risk because they ingested a neurotoxin and went into acute liver failure. And as we talked about the multi-organs, the liver is connected to other parts of the body, including the brain. They were very young when this happened. We don't know enough about what to expect, so we're erring on the side of caution. And being in pre-K is, again, very different from being in elementary school, middle school, high school, college, graduate school. So as their brains develop, they may, this concept that I don't think I mentioned to you, growing into the deficit, meaning you don't have the deficit now, you grow into it because your brain is not developing frontal lobes similar to other people, so you have executive functioning problems, or the tasks you're asked to do are beyond your capacity to read, understand what you're reading, right? So you grow into the deficits, meaning you don't have them now, but you can grow into them later on when your brain is supposed to be developing like healthy peers and the tasks become more complex. And I'm not just talking academic, social, athletic, etc.
Again, even if the children are doing pretty well now, that doesn't mean they won't experience these deficits as they develop. That's what the experts say, that's what the literature says. One more point about Dr. Bailey. You recall that I spent a pretty good portion, next please, of my examination of her talking about encephalopathy. Remember, encephalopathy is swelling of the brain? And I brought it up with her because when she did her review of the literature, she came to understand that encephalopathy is a factor that's been identified in predicting poor outcomes in children who survive acute liver failure. Her words, more likely to be at poor outcomes when the children have encephalopathy. So I asked her, you considered it, right? You looked for it when you reviewed the medical records? Yeah. But you didn't see it. And she said she didn't see it. And you know that's wrong. Because you've seen it with your own eyes. You've seen record after record of encephalopathy in these children. But even when confronted with those records, over and over again, she refused to agree that these children had encephalopathy. Even Real Water's own medical expert, Dr. Lin, who diagnoses children with encephalopathy when they're suffering acute liver failure as his day-to-day job, he disagreed with Dr. Bailey. Let's look at that.
Is it a fair statement based on your review of the medical records that several of these children suffer from hepatic encephalopathy?
Yes, sir. That's why part of the reason why they have, or why they have that diagnosis, acute liver failure.
So if an expert came in and said that they did not, that Harriet did not suffer from hepatic encephalopathy based on the records, that expert would be wrong, correct?
Based on these records, I would say Harriet has encephalopathy. Yes, sir.
You saw encephalopathy in the records. I would suggest to you that Dr. Lin disagreeing with Dr. Bailey and conceding that she's wrong about this raises serious questions about the credibility of her opinions. Let's go now to the verdict form. So this is the need for future neuropsychological monitoring and treatment part of the verdict form that Mr. Kemp showed you already. It's a simple part of the form. You just check yes or no. The evidence here, as I think I've demonstrated, far more likely than not, shows you that all 5 of these children need future neuropsychological monitoring and treatment. But don't just take my word for it or the words of plaintiffs' experts. Even Dr. Lin, Real Water's own medical expert, agreed that the children need future neuropsychological care. Let's play that clip.
Do you agree, Dr. Lin, that based upon the information, the medical records, everything you've seen in this case regarding these 5 children, that is appropriate for them to receive future neuropsychological monitoring as well as hepatic-related or liver-related monitoring?
Yes, sir. As I mentioned earlier, I think it's, even with normal liver enzymes, I think it's very understandable to want to continue to have some sort of monitoring with blood tests. I think that's very reasonable. And as I mentioned, it's, I think that family support and that psychological support is very important. So making sure that we have the supports in place to best support the child is critical.
Dr. Lin's own words. That psychological support is very important. Dr. Lin and Dr. Sands agree. And that's notable for one reason. Dr. Lin was talking about how these doctors work in teams when they're treating a life-threatened child suffering an illness like this. They work together. The brain doctors work with the liver doctors to come up with a plan. Both Dr. Lin and Dr. Sands work in this environment. They treat sick children every day. And they see this the same way. The kids need future support. Dr. Bailey doesn't really have that same experience. But these doctors both agree, Real Water's own expert agrees. Providing these children with the future neuropsychological care is the responsible thing to do. You should hold Real Water fully responsible and check yes, and allow the children to receive that future neuropsychological care. That's all I have. Thank you again.
Council can approach. Since our afternoon break, come back at 3:05. During this recess, you're admonished not to talk or converse amongst yourselves or with anyone else on the subject connected with this trial. Do not read, watch, or listen to any report of or commentary on the trial or person connected with this trial by any medium of information, whether without limitation to social media, text, newspapers, television, internet, radio. Do not visit the scene of events mentioned during the trial. Do not undertake any investigation. Do not do any posted communications on any social networking sites. Do not do any independent research, including internet searches. Do not form or express any opinion on any subject connected with the trial until a case finds submitted to you. Be back at 3:05.
Please rise for the jury.
Okay, are we ready in here?
Yes, Your Honor, ready to proceed. Please rise for the jury. Please be seated.
The council can come approach. Ladies and gentlemen, the plaintiffs ready to continue?
We are.
Okay.
Back to you, Tom?
Sure.
Good afternoon. Good afternoon. I want to be very brief. Let me give you a layout, ladies and gentlemen, of how this will continue. I'll give you my presentation in terms of Mr. and Mrs. Theodore. And after that, Real Water gets an opportunity to approach and present their opinion of how this case is proceeding. And then after that, we get to do a rebuttal, just so you'll kind of prepare yourselves. So I'll be brief in terms of Mr. Tagano's claims, and then later plaintiffs will have an opportunity to give rebuttal arguments, okay? Understood? All right. One thing I also want to point out up front, and I said this when we first met, all we wanted, all the plaintiffs wanted, were fair-minded people to evaluate the evidence in this case. That's all we wanted. Because we believe that reasonable minds can come to a reasonable conclusion based on an evaluation of this evidence. And that's all we're asking. What I also want to point out is that from the beginning of this case, and several days within the hearing of testimony, you probably heard Mr. Odou say that Real Water is taking responsibility. You recall hearing that? He said it a few times in relationship to the plaintiff's medical bills. He said it, I believe, on day 1, day 2, and perhaps he'd stop saying it after that. But hopefully you do remember that, those comments, as well during his opening. Let me say up front that Real Water has not paid a penny towards Mr. Tagano's medical bills, or any of the children, or any of the parents. I want you to be clear on that. I don't want that to be some false impression in your minds, that somehow they've taken responsibility by actually paying those bills, because they have not. Something else I want you to be aware of is you've seen the lawyers here be polite to each other. We try to assist each other in getting the evidence in front of you. I don't want that to be confused for a second with how much these plaintiffs have had to endure. While we're nice and pleasant with each other, I can guarantee you, when these plaintiffs were in the hospital, when they were on the flight for life, when they were getting spinal taps and biopsies, Real Water wasn't in that hospital trying to figure out what was causing it. Real Water wasn't there saying, I'm sorry. Real Water wasn't trying to figure out what in their product caused those injuries. That wasn't happening. Mr. Morales was by himself with his son. Emily on a plane. The carriers trying to figure out what's going on here. There was not a moment that they had any consolation, any politeness from real water. And I don't want this jury for a second to believe, or even not consider, what it means to this group of plaintiffs to have gone through everything they did, and then now, because we're so genteel here, we're so polite, to think that that was right. Because real water is going to ask you to be reasonable. Real water wasn't reasonable in October, November, December 2020. They weren't reasonable back in August in 2020 when people were getting sick. They weren't reasonable when Mr. Blaine Jones himself got sick and decided, I'm going to push the concentrate. But yet, real water would come to you and say, be reasonable in your numbers. Be reasonable. What strikes me as odd, and I'm a history, I wouldn't say a history buff, but I like history. Someone said, do not expect, I believe, justice for yourself if you don't give it to others. Very similar thing. The words aren't exactly the same. Abraham Lincoln said virtually something to that effect. Real water is going to ask you for reason and not compassion. Reason and not understanding. You know what's reasonable? Holding someone accountable for doing what was unreasonable. Holding someone accountable, when I say in this case, someone being real water, for what they've done, what they ignored, and the condition that they've placed these plaintiffs and their children without any concern for them or the public at large. That's what's not reasonable. Now, I've known the attorneys in this room for quite a while. And I don't want you to confuse my comments in terms of real water with how I feel about these attorneys. Mr. Odou has said to every plaintiff, I am sorry. I am sorry. I am sorry. I don't know how many times I've heard him say that. And I don't doubt that he is sorry. But has anyone seen Mr. Blaine Jones in this courtroom saying he's sorry to a single one of these plaintiffs? Have you seen Brent Jones in this courtroom say sorry to one of these plaintiffs? How about Amy Jones? This is not a trial about Mr. Odou's character. None of us has anything against him. But there's no mistaking that if real water wanted to take responsibility, they would have been here. They would have looked these plaintiffs in the eyes. They haven't done that. They haven't looked you in the eyes, much less these plaintiffs. And that's why we're here. Because they've endured 3 years of litigation, not including the time of being sick in 2020. They've had to go through depositions on behalf of themselves and their children. They've been here in this trial. They've had to go through medical records trying to figure this out. And now all they ask, all of these plaintiffs, including Mr. Tagano, they just ask for your fair and reasonable consideration. And to hold those accountable for being unreasonable, for showing a blatant and conscious disregard to the safety of them, their children, this community. And if you've learned, and you'll learn more, because there's still more left. What we've tried to do is put the evidence in front of you and let you make a decision based on the evidence. One thing I want to point out, and I'm having to go around all of the information that Mr. Kemp has given you and Mr. Mirkovich. They've given you a lot already. And me hitting cleanup, so to speak, I'm trying not to repeat everything they've said, obviously. But certain things stick out in my mind before I get to Mr. Tagano. I want you to consider this. Are you taking accountability when you simply try to poke holes in the foremost hydrazine expert in the country, but in turn, you don't bring your own hydrazine expert? Has Real Water put on any evidence, any, of how they created hydrazine? Any? A single person? No, not one. Because they, after it was decided, or after the FDA determined that there was a poison in that water, they decided not to bring an expert here to explain how they created hydrazine in their water. We, on behalf of these plaintiffs, had to figure it out. Is that taking accountability? Is that being responsible? And so every time I heard Mr. Odou saying that Real Water takes responsibility, no, they don't. They've not taken responsibility for figuring out what caused the problem. They haven't taken responsibility. Otherwise, these plaintiffs wouldn't be here. We wouldn't be here. I'd much prefer to be in some sneakers and some shorts and not here. But we're here because we have a responsibility for them, on their behalf, on their children's behalf, because their children can't be here. And I don't know if you guys remember this, and I say you guys somewhat friendly, ladies and gentlemen. I asked during voir dire, who are the most vulnerable people in our community? And right off the top, the first answer, children and seniors. Absolutely. And we have that represented in this case, and everything in between. But certainly we can all agree that the children have been harmed the most. Mr. Degano is the oldest of all, I hate to say that, Mr. Degano, the oldest of the plaintiffs here in his 70s, but he and his wife looking forward to being together in retirement. And now, based on what Dr. Hudson has said, they're not assured of that longevity. It's just not assured anymore because the most recent tests have shown abnormal liver, fatty liver, and abnormal liver. That's what they've shown. So he's not promised to have the years that they anticipate. I struggled last night, and I think I told you, when I struggle with thoughts, I'm on the treadmill. I struggled last night thinking about how difficult it must be for these families to have gone through what they've gone through. I thought about the biopsies, the spinal taps, the encephalopathy, the vomiting, the passing out. And then the juxtaposition of Real Water saying, I take responsibility. It just ate at me. Because you can't say that you take responsibility and have these plaintiffs go what they've gone through. You can't. It's irreconcilable, those two positions. Another thing I wanted to point out, because this happened last night. When we were going through the voir dire process, ladies and gentlemen, I talked about the scales, 50% plus. I talked about the weight of a butterfly on the scale. That's all you need in terms of preponderance of evidence. Just tip that scale. And last night, I don't know how this happened, but I felt that something bit me on my foot. I didn't know what it was, but I felt it. I walk around, I see a mosquito. I'm from South Carolina originally, Charleston, we were used to mosquitoes. But you don't have them here as often. So, and I thought about that in terms of preponderance of the evidence. While I did not feel that mosquito, it was on. It was on my foot. All you need with a precise scale is to be able to tell the weight of that mosquito on that scale to tip it. That's all the preponderance of the evidence is. That's it. Just enough discernible to tip the scale. We've done a lot more than that. We've had experts come in saying that the likelihood or probability of permanent scarring is closer to 90%. We've had experts saying that the permanency of fibrosis is over 60 to 80%, in between that area. No one is coming to you saying, well, it's barely tipping the scale, because that's not what the evidence shows in this case. The evidence has been replete, profound, and clear. And I don't believe the real water disputes this. Every plaintiff in this case suffered acute liver failure or injuries due to real water. That's what we know, including Mr. Tagano. Now, Mr. Tagano and his wife, could you put the picture of them on the screen? Mrs. Tagano is not here, unfortunately. Her father is going through a very difficult time. He may not make it. He's in a very bad condition. And so that's why she's not here. So that's Sylvia and Joseph. And the next slide, please. And these were Joseph's symptoms. We've gone through them. And the only reason I put them up, because if you look at them again, you see how similar they are to all of the studies we've looked at, the other plaintiffs in this case. I think the only difference, really, is his age. But we've seen all of these symptoms repeated in the medical records. Next slide. These are his AST and ALT scores from his initial collection date of November 5th. You recall he was in the hospital 4 days. Go right ahead, Shane. That's the 6th. You can see his AST, ALTs increased. And it went back down. This was his second stint at Summerlin Hospital Medical Center. Next slide, please. Now, these are the later tests that we discussed. He had a test in January of 2022, which showed abnormal liver. Can you show that page, page 2? 2 months later, he took another test. Again, this one showed abnormal liver function test and fatty liver on ultrasound. The literature shows that hydrazine poisoning can cause fatty liver. That's what happened here. It happened also with Hera Carrier. And then finally, the March of this year, liver test. Again, abnormal liver function test. Dr. Hudson came in and explained why those tests concern him, and why that's an indication of permanency in terms of liver damage. Next slide. Before we start this portion of Mrs. Tagano's testimony, this was something that struck me as well. Mrs. Tagano, and neither of them are complainers, but also they did not cry. They got close, which I think shows the strength of both of them. And she's very spiritual, but she seemed to get most emotional when she was concerned about him, and he seemed to get most emotional when it concerned her. And that tells you, they've been married since 1979, and that just tells you, just how close they are, and why it's so important that this product has perhaps shortened their lives together in the future. Let's hear what Dr. Hudson says. We just look at him for a while. Are you aware of the fact that Mr. Tagano had subsequent liver tests in 2022 as well as 2024?
Yes, sir.
Let me show you slide 94. This was done on January 25th, 2022. It's exhibit 827, which has been admitted to this case. What's your impression of this impression?
Well, what I would be worried about is this continuation of abnormal liver tests as a direct result of the injury that he occurred a few years earlier, secondary to the real water.
Let me show you 2 months later, he took another blood test, and this was the impression. Again, would you have the same concern?
I have the same concern because, as I mentioned before, uniformly, people that are exposed to real water with hydrazine develop fatty liver.
Is fatty liver bad?
It can be, yes, sir, because it can lead to scarring and cirrhosis.
And then finally, just a few months ago, in March of 2024, another blood test, and this was the result. Are these later tests showing a consistency in his abnormal liver function?
It does.
Would that concern you, Mr. Pepperman?
Yes, sir.
Do you believe all of the acute liver failures that we discussed now, each of the plaintiffs, all caused by real water?
I do believe that.
And so Dr. Hudson made no conditions, no caveats. He simply gave it to you straight. Because of Mr. Tagano's consumption of real water, and more likely than not, phraseology, his liver has been permanently damaged, and he will have complications from that. That may affect the length of his life, and the length of time with his wife. So let's hear Mrs. Tagano's concerns about this. At some time, Mrs. Tagano, did he pass out?
Yes, yes.
Describe that to the jury.
Actually, it was when he was going for a blood work. He needed to go for blood work. His doctor said they him for some blood work, and we went there to LabCorp, and I got him there. We walked from the car and walked into the lab, and he was there. Went back to give the blood, and then a tech came out a couple of minutes after he went in, and she said, "Come on back." So I went back there, and you know how those chairs are with like you give blood, and then it's like he was hunched over, his head was down, and he was unresponsive. And I looked at the tech and I said, like, "What's going on?" She said, "Well, he fainted, and see if you can talk to him." I said, "Okay, well," I said, "Okay, Joe, are you okay? Are you okay?" Rubbing his back, and I felt he was trying to communicate with me, but he really couldn't. He really couldn't. And they had called. I said, what are we going to do? Should we call the fire department? We called the fire department paramedics.
Yes, sir. And the paramedics arrived. So I wanted to set the stage for how Mr. Tagano felt when he could hear his wife speaking to him, but he could not respond. I want you to hear that first, and then I want to hear finally what Ms. Tagano said about her concerns. Do you recall passing out at that point?
I do.
And what do you remember about that occasion?
I don't remember a lot, but the little that I do recall
Yes, sir.
is that I went back for, my wife took me to LabCorp for a blood draw. And what I do remember is I remember being in a chair like this. And I was down, my head was down, and I could hear my wife say, "Joe." Excuse me. I get emotional thinking about my wife. I had my head down, and she said, Joe, are you there?" And I could hear her, but I couldn't respond. And it was very upsetting. I mean, I just was out of it, but I could hear her saying, "Joe, can you hear me? Are you there?" And I could hear her, but I couldn't respond.
Yes, sir. Now, Mr. Tagano is a two-deployment Vietnam vet. Combat medal recipient. He's not a soft guy. And that, his inability to respond to his wife tore him up, to the point where he almost began crying here. That shows you how devastating it was for them. And again, as bad as that was, and I've had this conversation with Tagano, I can only imagine what the parents of those children went through. Now, I want you to hear what Mrs. Tagano said. Do you have any concerns now because of those tests with your golden years, Mrs. Tagano?
Yes.
Can you tell the jury what those concerns are?
Sure. We're very positive people. We are spiritual people. And I just would like to say that however long we have, but I do believe this particular situation has set some sort of finiteness to the whole situation in terms of however long we can enjoy each other. And so be it. That's where I'm at.
Yes, ma'am. So it's clear that both Mrs. and Mr. Tagano have been affected. Now, only Mr. Tagano is a plaintiff in this case. But I wanted you to see how his injury permeates his family. And he's got 2 children and 4 grandchildren. Mr. Tagano's name will appear on the verdict form. If you could, Shane, please put the verdict form on. I'm suggesting for Mr. Tagano, $2 million, similar to Brian Wren, and $2 million in future. Now, I will tell you, this is going to be your decision, and there's no formula. I said that up front, said it through 3 days of voir dire. I know you guys remember it. But I thought about this number because while everyone's story is different, my concern for the Taganos is the next several years from now. They don't have the same length of time as the children. You expect when you get to this age, you're starting to enjoy life, you travel, you play golf, you do whatever you do, garden. But now he's got 3 consecutive abnormal delivery dates. So that's my concern for the future. The past, I compared this to Blaine Jones's comments. That's the only evidence we have, and that's all we got. I mean, it's weird that you would have the person who created the product actually be the person who also said that he wouldn't go through this for $10 million. Now, Mr. Tagano spent more time in the hospital than Blaine Jones. And he didn't cause this problem. So I'm asking for 1/5 of what Mr. Blaine Jones said it was worth. So we're trying to be reasonable. And we ask that this be the award for Mr. Tagano, both in past and future pain and suffering, this is the general damages we were speaking about earlier. Ladies and gentlemen, I'll get another chance to speak with you in rebuttal, but I want you to consider this in terms of the compensatory part of it, in terms of the punitives. Mr. Kemp here has certainly laid out a lot of the reasons why punitives are justified here, and I believe I'll be able to touch on it some more. Thank you very much.
Just give me 1 second, sure.
Oh, Joel, do you want this?
Yeah, 1 second. You put it on the desk, that would be wonderful.
Yeah, no worries.
Thank you, Your Honor. Appreciate the courtesy. Sure. Good afternoon, ladies and gentlemen of the jury. I appreciate the courtesy. When this case started, One of the questions that I had for all of you, and some of the people who aren't here, is I warned you, this is a serious case, involves injuries to children. And now that you've heard the case, I'm sure you would probably agree that that warning was probably, well, maybe that warning wasn't even sufficient. I want to thank all of you, though, for not raising your hand and for staying with us in hearing this case. It's a difficult case. The parents have been through a lot. There's no doubt about that. And hopefully you haven't taken anything that we've said to in any way impinge upon the victims of real water. The parents did an amazing job with their children. And I'm going to talk about that. And I think Mr. Tagano did an amazing job. And I want to start with, let's go to the third slide. This is one. So I'm going to talk about some of the evidence in the case. I'm going to talk about kind of what you've heard in the case. Then I'm going to talk about the jury verdict itself and the damages. And then I'm going to talk about the punitive damages. As part of that, I'll also touch on the jury instructions. So the way this process works is, you've heard now from the plaintiffs in their closing argument. I will make my argument, and then there will be a rebuttal argument, presumably by Mr. Parker, although they have the right to make three because there are three groups of plaintiffs in this case. But you won't hear from me further as to this part. So this is my only opportunity, so what I've got to do is I've got to respond to the three arguments you've heard, as well as what I think the rebuttal will be. So what I want to do is just kind of start where we started, which was, this was a family business. You've heard from testimony from Brent and Blaine Jones. You have not heard from Amy Jones. Her testimony was not played. The business started in 2008. They believed in their product. You've heard testimony about that. You've heard how even Blaine continued to drink the water after his injury. And again, that doesn't excuse what happened to the plaintiffs. The plaintiffs were injured. There is no doubt about that, and we're going to get to that. The plaintiffs were injured and they continued to drink real water and got, some cases, new injuries. There's no dispute about that. But the Joneses believed in this product. You saw Mr. Marlowe believed in this product. Even Mr. Randolph, after everything he's heard, still believes in this product. And they drank the water themselves. Again, that doesn't excuse what happened. That just explains, how much they believed in this product and how difficult it was for them to finally reach the conclusion that the product had hurt people. And there's no doubt that their product had hurt people. We're not disputing that. So let's go to the next slide. Again, the only reason why I'm putting this up here is because some of this goes to what Dr. Hutton said. Dr. Adams Hutton, she hyphenates her name. I want to be respectful and get her name right. People screw my name up all the time. I try not to mess other people's names up. Blaine, as you heard, made all the concentrate. And he got the recipe from the inventor, John Marlowe. John Marlowe didn't set up the company. You've heard his testimony that he only made the concentrate. Initially, Brent Jones and Blaine Jones set up the company. They hired an FDA consultant. You've seen testing that was done, even using gas chromatography, CS. They drank the water themselves, and there is no dispute, there's no evidence in this case that they had ever heard of hydrazine before the FDA found it. The FDA, there was a recall in March of 2021. The FDA tested the water. That testing result came back in October of 2021. So let's go to the next slide. All right. I want to talk about the fact that Real Water is responsible for your verdict. Real Water has conceded liability in this case. They have conceded their product was dangerously defective. They have conceded that it injured these specific plaintiffs. That's what it means by they've conceded causation. Real Water has conceded medical monitoring for these plaintiffs, all of them. We'll talk about that. And they've conceded psychological counseling for the adults. And the reason why they've conceded psychological counseling for the adults, and we'll get into this in some detail, is Dr. Bailey, her opinion was that was the best way to address the injuries. And supporting the parents, and you heard Dr. Wren say the same thing, supporting the parents of these children is what is key. And that's why they have a difference of opinion between Dr. Bailey and Dr. Sands. And all it is a difference of opinion. In terms of the costs, we'll talk about that. That's been conceded. So if you decide that the children need psychological counseling, neuropsychological counseling and monitoring, we're not going to dispute the cost. We've reached an agreement with the plaintiffs. That cost will be added to the verdict, so you don't even have to worry about it. You just have to answer yes or no. And the last yes or no question is the punitive damages question. Now, Mr. Parker, in his presentation, talked about the fact that Real Water didn't have a hydrazine expert. Real Water doesn't need a hydrazine expert. Real Water will tell you, and has told you, there shouldn't have been one drop of hydrazine in this water. That is undisputed. Real Water has adopted, if you will, the opinions of Dr. Najm. They agree with him. My only quibble with Dr. Najm, which isn't even a quibble, my only observation of Dr. Najm is he can only tell you two possible ways it was created. He's not sure. That's all. Okay? It shouldn't be there. It doesn't matter how it was created. It shouldn't be there. And the fact that he can't tell you definitively, I think that's a minor fact, and I think it does go into punitive damages because it was unexpected, and we'll get to that. That's all it is. It's a minor detail. But there shouldn't have been one drop of hydrazine. That is absolutely, positively undisputed. Let me just do a few things right now. Mr. Zamora, pull up the jury instructions for us, please. I'd like to start with jury instruction number 11. And I'm going off script here, but that's the danger of going third, or fourth, I guess. Now, Mr. Parker correctly observes that Real Water has not paid a dime in this case. That is absolutely 100% true. They have not. There will be a verdict after this case is over, and the medical costs will be added to the verdict, as well as some of the other things that we're going to talk about. They will be added to the verdict. So when we have said that Real Water is responsible for those, we mean Real Water is responsible for your verdict. Real Water is responsible for the things that will be added to your verdict. And hopefully, nothing that we have said caused any confusion. As you see there, if we skip down to the next paragraph, this is something that we have said over and over again. I said it to the board here. Statements, arguments, and opinions of counsel are not evidence in the case. Okay? So our argument, if you will, is just to point out certain facts to you so that you're aware of them. I'm not going to do that in my presentation today. I'm going to point out some facts that perhaps we went too fast. We have this unnatural process where we present the evidence. We hope you heard it. Sometimes we repeat ourselves because we want to make sure. There's nothing worse for us when the case is over and we talk to a former juror and they say, oh, I didn't understand that. And then we all are sad. We want to make sure that we present the evidence as clearly as possible to you to try and make your job easy. And your job is not easy. You have to come up with damages in this case. That is not an easy job. And damages for children is not an easy job. And the instruction, number 11, goes on to say, if the attorneys stipulate, that means agree to the existence of a fact, you must accept that stipulation and its evidence in regard to the fact is proved. The only, again, minor quibble, we have agreed, we have stipulated as to the cost for medical monitoring for the plaintiffs that were injured. We have stipulated, agreed on the amount of the medical bills for those people. And those facts are proved. Plaintiff wins on those. Okay. Let's go to jury instruction number 18. This is the hard one. This is the tough job. And we have endeavored as the attorneys in this case, but the plaintiffs and the defendant, to make your job as easy as possible, but we recognize it's not easy. You've got to determine the amount of damages for each plaintiff. You've got to consider the nature, the extent, and duration of their injuries. You decide the amount of money. And you decide the amount of money, or sum of money, sufficient to reasonably and fairly compensate each plaintiff for the following items. So there's the word reasonable. Mr. Parker doesn't dispute this jury instruction. Mr. Parker is giving you some righteous indignation that these people were injured. These people shouldn't have been injured. I don't dispute that. Real Water doesn't dispute that. We're not going to argue that these people shouldn't have been injured. It's terrible what they went through. So in trying to come up with the amount of money, this jury instruction number 18, I won't go through the whole thing. You'll have it. I believe it's already been read to you by the judge. It's been referred to by Mr. Kemp. We all agree that this is the law. And anything that we say, we're not arguing with the law. We're just here to argue how the facts came out in this case and how the facts apply to that law. Okay, let's go to jury instruction number 19. Again, this is part of the tough assignment that you have. There is no fixed standard for deciding the amount of pain and suffering damages. And that is, I don't know if we counted up the number of lines in the verdict form, that is probably the majority of the verdict form is past pain and suffering and future pain and suffering. We acknowledge that this product caused pain and suffering and will cause future pain and suffering. Okay? You must use your judgment to decide upon a reasonable amount based upon the evidence and your common sense. So again, we're not saying be reasonable because you like real water. You probably don't like real water, and that is understandable. We're asking you to be reasonable and use your common sense because that's what the law requires. And that's what, and even requires is such a strong word. It's really, you use your common, the law doesn't want you to set aside your common sense. You come up with the damages, not real water, not the plaintiffs. Okay? I'm going to suggest some numbers to you on behalf of real water, just like the plaintiffs have, but you don't have to listen to any of this. You come up with the numbers, okay? All right, let's go back to the script, if you will. And I want to highlight some of the things. Let's go to the next slide, Mr. Zamora. All right, again, these are the past medical expenses that will be added to the verdict. They're helpful to know these numbers when you decide upon pain and suffering. They're a yardstick. They're an indication. They don't take away from the pain and suffering that the plaintiffs went through. They don't replace the pain and suffering. All they are is one small measure of how badly hurt these people were. And these people were hurt badly. That's not disputed. All right, let's go now. I want to talk about some of the evidence in the case. And I want to focus in on, I'm going to do it twice. I'm going to talk about the evidence about punitive damages because nothing I say is going to excuse the fact that these people were injured and made sick. The only reason that I'm going through these complaints is because of the punitive damages element, because I'm going to ask you for a different result than the plaintiffs had asked you for. So when this case started, the very first day, after we did our opening statements, there were 3 witnesses presented to you. Susan Doran, Lois Kessler, and Robert Fisher. Actually, Fisher may have come the next, no, I'm sorry, Fisher came that day too. So let's look at Susan Doran's email, which was Exhibit 31 to the case. This is the email that she sent to Real Water. And she says in her email that it's her guess that Real Water is using Vegas Valley water. It is a hard water, which my whole life has given me diarrhea. So Susan Doran, in her email, is telling Real Water what she believes made her sick. Real Water used Vegas Valley water. We've seen the pictures of the pumps. We've seen the water coming into the building. Plaintiffs would have you believe that Susan Doran was made sick by hydrocine. Plaintiffs have, as they have said, the world's most authority on hydrocine, Dr. Najm. Dr. Najm has not come in here and said, to a reasonable degree of scientific probability, that hydrocine was in the water consumed by Susan Doran. Okay? All we know is she said the Las Vegas Valley water made her sick, and Real Water took her at her word. Dr. Adams has a criticism of that. That's fine, but those are the facts. You, the jury, will determine how those facts apply to the punitive damages. All right, let's look at Susan Doran's trial testimony from May 31st.
In one of the emails, they promised to give you 2 more cases of water. Did they do that?
I didn't want any more of the water. I wanted them to fix the problem.
Back when you alleged you were sick using Real Water, did you seek any medical treatment?
No.
Did a medical doctor ever tell you your symptoms were related to the consumption of real water?
No.
So for the adults in this case, there's been one medical expert, Dr. Hudson. And the reason why there's been one medical expert is because both sides agree with Dr. Hudson. Real water agrees with Dr. Hudson. Dr. Hudson has not come in before you and testified to a reasonable degree of medical probability that Susan Dorn was injured by hydrazine or she consumed hydrazine. Neither has Dr. Najam. Okay. All right, let's see Lois Kessler's testimony. Oh, I'm sorry, this is her complaint first. Let's look at her complaint. So, as you'll recall, Dr. Adams had criticisms about real water not sending the water out to be tested. And we know, in the case of Lois Kessler, the water was sent to Silver State analytically. So, this handwriting is from a real water employee who took down the complaint and gave it to the people responding to the complaints. And as we'll hear, the people responding to the complaints or evaluating complaints generally were the owners of real water. It's a small company. Brent Jones, Blaine Jones, Amy Jones were the ones to respond to complaints. So there it is. They sent the water out for testing. Is this test going to find hydrazine? No, it's not. Because Brent Jones, Blaine Jones, all of the people who have testified in this case testified that they didn't know what hydrazine was. Does that excuse the fact that the plaintiffs were injured? No, it doesn't. All right, let's look at the next slide. All right, now we have Mr. Fisher. If we could blow up his email. All right, Mr. Fisher testified via video. He purchased 2 1-gallon jugs of water from Sprouts in Tampa Bay, and he drank 1.5 gallons of it within a 6 to 8 hour period. All right, well, what does Dr. Hudson, the only doctor who's testified about adults in this case, say can happen if you drink 1.5 gallons in an hour? He talks about water intoxication. Again, did Dr. Najam say that Mr. Fisher was made sick by real water? No. Did Dr. Hudson say that Mr. Fisher, to a reasonable degree of medical probability, was made sick by real water? No. So, again, does that excuse the fact that these plaintiffs were made sick? No, it doesn't. All right, let's go to the next one. All right. Let's see which one I can see better. This is another one that Dr. Adams had criticized real water about. And we can see in this complaint form that somebody on behalf of real water, a representative, went to the Chevron, bought some bottles, including some from the same manufacturing date. Store personnel said no problems about the water taste have been reported then. We then tested the pH, ORP, and TDS on the store-bought bottles and on the control bottles. So we just heard plaintiffs allege there were no control bottles, there were no controls, there were no proper testing. Well, now we know that this one in 2014, there were control bottles, they were tested. Does the fact that, let me say this, did Dr. Najam say, well, this complaint, to a reasonable degree of scientific probability, is because of hydrazine? No, he didn't. Did any of the plaintiffs say, yeah, the water that we drank tasted like gasoline? No, they didn't. Can hydrazine taste like gasoline? I'm going to take Dr. Najam's word for it. I'm not going to go drink hydrazine. And again, does this excuse the injuries to the plaintiffs? No. No, it doesn't. All right, let's talk about Steve Watkins. Mr. Watkins, very nice man, came here, has been injured by real water, testified to you, he's a plaintiff in another case. His wife sent the email saying that his doctor wants him to stop drinking alkaline water. Is there a why? No. Is there a reason? Is there some allegation that it's real water and real water has hydrazine in it? No. Should they have jumped to the conclusion? That's up for you to decide. But again, Dr. Najam didn't say to a reasonable degree of scientific probability, and all we know is what the email says and what Mr. Watkins testified to. All right, let's go on to Jeffrey Dosatel. Mr. Dosatel seemed to have trouble recalling when he worked for Real Water. Okay. Initially, he said, as you remember, it was in 2017, 16, and he said 16. You were there for how long? About 8 months. So 16 to 17. Again, I don't remember the months. Well, we'll see. He also has the year wrong. And then he says, he makes the bold statement, and did Real Water have a HACCP program? No, they did not. All right, hold that in mind while we look at some of the audits between all the times that Mr. Dostal could have worked at Real Water. All right, so first we're looking at, boy, I'm going to approach this so I can see this really. Thank you. Sorry, I know post-COVID makes people nervous when I get too close. So we know in 2014, well before Mr. Dostal worked there, we have the audit contact code Payne. We have Wren Jones as a contact. We know the auditor from NSF, and we know that Real Water got 95.6 on their HACCP score. So we know that Mr. Dostal was mistaken, that before he worked at the company, there was a HACCP program. Will you see the next one, Mr. Zamora? All right, now we're in 2015. Again, we know that facility contact is now Tom Pham and Amy Jones and Blaine Jones, and we know there's a HACCP program because there's a score. And
They're
they
all
didn't
to
do
be
great. They got 78.3. We haven't tried to hide from the jury the scores that they got. We're going to see the failing one in a minute. Let's go to the next one, Mr. Zamora. Oh, let's focus in on this. So under HACCP, this came up, whether Mr. Dostal or Patty Converse was the HACCP employee. Well, we know in 2015, Andres Vargas took the HACCP training, and he was the HACCP employee. We're going to see his name in some additional audits. So let's go, and yes, 100% for that category. Let's go to the next one, Mrs. Zamora. All right, now we're in 2016. HACCP score 81.8. College, that's probably passing. I don't know for the NSF audit. Let's go to the next one. Again, 2016, Andres Vargas is the HACCP trained employee. So again, if Mr. Dostal was there, he is mistaken. Let's go to the next one, please. March 2016, HACCP, 100%. Who's the employee? Andres Vargas again. Again, Mr. Dostal, maybe he didn't start there yet, but he's wrong. There's a HACCP program and there's a HACCP trained employee. Let's go to 2017. HACCP, 94.1%. March of 2017. The audit contact is Patty Converse, so she's the contact. All right, do we have the HACCP employee in this one? I don't recall. Okay, so we have, let's go through this one only because it's the time that Mr. Dostal has criticisms of Real Water. They talk about the meters being used to make the water, being tested every 2 weeks. They don't have any complaints on the Costco product line from this location. Other types of complaint records are maintained on file. So the auditor, at least, was able to see the complaints. Let's scroll down. What's next? They have a HACCP, reviewed HACCP team meeting minutes from 7/29/2016. They don't, at this point, have a current person trained on the program, so they get 0 for that. But they have a HACCP plan. They have a description of the product. And the ingredients. Again, Dr. Adams Hart was critical about the description of the ingredients. Well, we know for a fact that Blaine Jones made the concentrate the same way every time. And we know from the audits that the ingredients are listed. And actually records are signed and dated as part of the annual HACCP meeting list. All right, let's go to the next one. Now we're in 2018. All right, this is the audit that they failed. I think everybody agrees on that. 6.7 is not a great score. All right, let's go through this one. If we go to the top. All right, so they have problems with their caps. They're still doing okay on the measurements of the TDS. Oh, look at that, number 19, SOP, standard operating procedures on file. Dr. Adams Hutt, who didn't review any standard operating procedures, mistaken. Again, customer complaints on file, but no complaints related to Costco. Certainly this auditor was not shy about calling out deficiencies. Let's go to the HACCP section. Let's see, this is the fail. HACCP team list is not current. 4 member positions listed, or 3 of them are currently handled by the VP of Operations, elected VP, presumably Blaine Jones. No current staff has completed HACCP training. Okay? So we know that this audit in 2018, which is after Mr. Desico no longer works there, presumably, there was no HACCP trained person who failed the audit. Is there anything else on this one, Mr. Warren? No. Okay, so 3 months later, in February of 2019, Mr. Desico was long gone by then. We have back to 100% HACCP score. And Blaine Jones has now been trained as a HACCP person. We see the quality management section. They've got a good score, 100%. You see the HACCP. They've got a HACCP training was completed by Blaine Jones. They've got a HACCP score available. Product specifications are on file. Flow diagram is accurate. The auditor has verified the flow diagram. They've got hazard analysis completed, control measures identified. I don't think we have anything else on this one. This is more. HACCP plan was validated and record keeping is in place. And then what's on the bottom of the page? Is there anything we want to talk about? I guess not. All right, so cross-examination. Mr. Kaufman got out and cross-examined Mr. Desico. And Mr. Desico confessed, yeah, he's confused as to when he was there. And you think he quit before the end of 2018. So, again, are we critical of Mr. Desico for not recalling where he was 6 years ago? No. It just shows that he was not accurate. Okay. Mr. Desico has had many jobs since joining the private sector, and the fact that he's got some recollection difficulties is neither here nor there. All right, what's the next slide? All right, again, there is no dispute. The real water injured the plaintiffs, and you should award reasonable damages. Let's see. I think I might have skipped one. You know, what we didn't see on any of those audits, we didn't see that Patty Converse was the HACCP person. I just make a big deal about the fact that Patty Converse left in July of 2017, but she's not the HACCP trained person on any of the documents that we've seen. All right, what's the next slide after this one? All right, let's start talking about damages. We've said this several times. We don't mean to beat this in, but I think, again, it's helpful to know when you hear what we're going to talk about for the jury verdict, what the damages are so far. Real Water admits that the past medical specials were reasonable. They were caused by Real Water. They're $215,000. Real Water admits, and this is going to be for all of these plaintiffs, that $50,000 in future medical monitoring is reasonable and appropriate for the parents. And I think it's for the children too. In fact, this is no rent, so it's for the children too. Those numbers won't appear on the jury verdict, but it's something that's just admitted. It'll be added to the verdict later. So the court and the parties are asking you to come up with past physical, mental pain and suffering, anguish, etc. I'll talk about that when we get to the verdict form. Let's go to the next one. Care carrier. Again, future medical monitoring is admitted by Real Water, $50,000. Past medical specials, $262,000, admitted by Real Water. Let's go to the next one. Lyric Williams, $319,000, admitted by Real Water. Future medical monitoring, $50,000, admitted by Real Water. Let's go to the next one. London Williams, $174,000 admitted by Real Water. Future medical monitoring, $50,000 admitted by Real Water. Has Real Water paid those? No, they haven't. Next one. Severn Morales, $357,000 and change. Future medical monitoring, $50,000 admitted by Real Water. The only expert that testified in this case as to future treatment of the plaintiffs, again, was Dr. Hudson. Dr. Lynn agrees with Dr. Hudson. It's not a dispute. All right, let's go to the next one. Christopher Brian Wren, Mr. Wren, I guess we would call him. Nearly $80,000 in past medical. Future medical monitoring admitted by Real Water. Future neuropsychological care allowance admitted by Real Water. Real Water admits that for the plaintiff parents, $60,000 for basically support services like Dr. Lynn talked about, like Dr. Bailey talked about, are reasonable, necessary. You won't see them on the verdict form. You're going to see a different issue that we're going to talk about. But there is no dispute that the parents deserve support. You've seen all of the parents come up to this stand, and we have tried not to make the situation worse for them than it already is in our examination of them. We ask them how they're doing. We've asked them if they haven't had any counseling. For the most part, they haven't. We know that the Wren family has had some in relation to autism. That's not the issue here. The issue is the damage that Real Water did to these people and the counseling that they deserve. And Real Water admits they deserve it. Okay? And Real Water believes that that's the best way to take care of the children is to support the parents. Let's go to the next one. Emily Wren, again, $32,000 for past meds, $50,000 medical monitoring, $60,000 for future neuropsychological care. Again, it's an allowance. There's two parents, so they both deserve it. Emily Wren testified in front of you. She's a great mom. She went to the hospital with COVID and took care of her child. Okay. Let's go to the next one. Joseph Tagano, one of our 3 adult injured plaintiffs, $86,000 in past medical bills caused by Real Water. Real Water admits that. Future medical monitoring, $50,000 for the medical monitoring, the liver function tests, the various tests that Dr. Hudson said. Future neuropsychological care, if he so chooses. He doesn't have to get the care. He gets the $60,000 regardless. It'll be added to the verdict. Let's go to the next one. Brian Carrier, same thing. We're admitting future counseling should he choose to use it. Next one. Erica Carrier, same thing. There is no doubt, none whatsoever, that these parents went through, I'm going to say the word hell with their children. There is no doubt they should be compensated for that and that they should have care for that. Let's go to the next one. Santee Williams, single mom of twins. You heard her story. We've asked her if she's had counseling. She has not. Again, in the future, she's going to have an award in her favor should she choose to use it or not. You will decide the past physical, mental pain, suffering, and anguish she went through, and the future physical, mental pain, suffering she went through. Excellent. Jorge Morales, single father, did a great job. Future neuropsychological care should he so choose. Jorge Morales is a hero. He saved his son. His son had to go back to the hospital. He fought for his son's rights and for his son's care. He did a great job. Go to the next one. All right, so here's the verdict form. We have some differences of opinions as to the amounts. Let's go through the amounts. All right. Christopher Noah Wren. This is past physical and mental pain, suffering, anguish, disability, permanent injury, loss of enjoyment of life, $1 million. Eric Carrier, $1 million. Eric Williams, $1 million. They're all $1 million for past. Does that, Lennon Williams, does that diminish in any way what they went through now? That is a recognition of what they went through. Let's go to future physical mental pain, suffering, anguish, disability, loss of enjoyment of life for the children. Kristen Wren, $1 million. Eric Harrier, $1 million. Lori Williams, $1 million. London Williams, $1 million. Southern Morales, $2 million. There is no doubt that Severin went through a lot. That Severin and his father went through a lot. All right, do the children need future neuropsychological monitoring and treatment? You've heard Dr. Lynn, you've heard Dr. Bailey, you've heard Dr. Sands, and there is no dispute that family support is important. Dr. Bailey has a different way of going about the family dispute, family support, than Dr. Sands. Dr. Bailey believes that the allowances for the parents is the best way to go. Dr. Sands believes they should be evaluated. You heard Dr. Bailey's criticism of evaluating the white coat syndrome. Some people get nervous when you go see a doctor. And that's why we suggest voting no for these. Now, the plans are critical of Dr. Bailey, who is not an MD. Dr. Bailey does not diagnose encephalitis or encephalopathy. Dr. Bailey only reviews the medical records. She relies upon an MD for the encephalopathy. And Dr. Bailey did her best to recall the medical records. Dr. Bailey is not providing an opinion contrary to any MD in this case, never would. All she has is her experience, her clinical training at UNLV, and the basic scores that were given to the parents by Dr. Sands. Dr. Sands admits you can't predict the future. Okay. Both sides admit, thankfully, there's not a lot of research on children injured by hydrazine. And so the medical professionals opine upon the medical injury, the psychological professionals try to opine upon the psychological injury, and you, the jury, ultimately decide yes, no. It's your decision. You've heard the testimony. You've heard what's going to be going on with the parents. If you still believe that the monitoring of the children psychologically proposed by Dr. Sands is appropriate, we've agreed with the plaintiffs on the amount that will get added to the verdict. You don't need to worry about it. All right, let's go to the adult plaintiffs with liver injury. All right. Christopher Brian Wren, what he went through was terrible. $500,000 for the past physical and mental pain, suffering, anguish. Emily Wren, same amount. Joseph Tagano, same amount. Now again, I guess the plaintiffs were critical that there was no expert to challenge Dr. Hudson as to the injuries of Joseph Tagano. He was injured. The question is, the difficult calculation as to pain and suffering damages, that is up to you, the jury. Let me say another thing about the pain and suffering numbers and about the fact that the person who has injured these people is recommending numbers to you. That in and of itself sounds horrible, and we acknowledge that. You, the jury, have to look at what they testified to, what the evidence is, and come up with a number. So please don't be offended that we're recommending a number. All it is here's a number. You decide if that's reasonable. If it's not reasonable, don't follow our number. The plaintiff's number is not reasonable. Don't follow their number. You decide what the number is. All right, sorry, I took a digression. Future mental pain, suffering, and anguish. Fortunately, the adults are doing okay. Not great. And certainly nothing that we have said should be interpreted that we're trying to minimize what anybody went through. $50,000 for Christopher Brian Wren, $50,000 for Emily Wren, $50,000 for Mr. Tagano. All those are is a number. You ultimately will decide what the right number is. All right, the plaintiff, parent, plaintiffs, past mental anguish related to their child's injury. Again, the plaintiffs all of the parents took the stand and all of the parents testified before you what they went through, and you've got to decide what number is reasonable. We're going to suggest $100,000 for Christopher Brian Wren, Emily Wren, Ryan Carrier, Erica Carrier, Santee Williams. And we stop there before you go to the next page. And the reason why we are suggesting those numbers is there's no science to this. There's no formula. You can't just say, okay, medical costs were this, and then multiply that times 2 or 3. That doesn't work. You have to, but as a jury, we've asked you to do the very hard thing, which is find a number that you agree with and talk amongst yourselves and deliberate, follow the law, and give us a number. All right, Jorge Morales. We suggest $500,000. Does that, you know, or can you compare what Jorge Morales went through? I have a friend, Jorge Gonzalez, if I keep goofing that up. Can you compare what Jorge Morales went through to any of the other parents? No, you can't. It's just a number. It's the best we can do in our system to try and make somebody whole. But you can't give them, you can't make them forget what happened. You can't take that away from them, nor would we want to. That's not our job. We just want you, the jury, to come up with a number that you believe is reasonable. All right. Let's go to future mental anguish related to his or her child's injury. Again, this is a hard one, right? You, as a parent, any parent who's had a sick child, you always worry. I kid people, you know, you can, as a parent, the last night of good sleep you ever have is before you find out you're going to have a child. And you never sleep right again. And that doesn't diminish what these people went through. It's natural. It's a parental instinct to worry about your child. We're going to throw out some numbers. Again, you don't have to accept our numbers. Christopher Brian Wren, $100,000. Emily Wren, $100,000. Ryan Carrier, $100,000. Erica Carrier, $100,000. Cynthia Williams, $100,000. And again, Jorge Morales, $500,000. Now, lastly, we suggest that you check no for the punitive damages, and let me explain why. So we go back to the, thank you, Mr. Samara. Let's go to the next one. And the next one. All right, we talked about the jury instructions. Plaintiffs went through them, I think, fairly adequately. So I'm just going to quickly go through them. Clear and convincing evidence that the defendants, Real Water, are guilty of oppression, fraud, malice, and conduct, providing for the basis of liability. Next one, please. They covered this. Again, the hazard of me going after them is I don't know what they're going to say. They covered this pretty well. Let's go to the next one. Conscious disregard. They covered this pretty well too. Let's go to the next one. All right. Again, it's a box to check. The plaintiffs have covered this. Let's go to the next one. Clear and convincing evidence. Okay, that's what we're talking about. That's what you're looking for. Let's go to the next one. All right. Is this a video? Would you play this for me, Mr. DeMora?
Well, can you describe in very, very general terms what this is? This is a letter from 2017. What is this?
This is a letter from Silver State Analytical Laboratories here in the Vegas area, who the company used to do various testing, and as a third party certified lab to do the testing.
And what were they testing?
The product.
The finished product?
Finished product.
How often have they been testing?
They would do weekly testing, quarterly testing, yearly testing, and then another more comprehensive test every 4 years.
Real Water concedes that none of those tests would have found hydrazine, nor did they. Real Water didn't know what hydrazine was. John Marlowe didn't know what hydrazine was. Does that excuse them from injuring the plaintiffs? No, it doesn't. Go to the next one, please.
At one point, did you become aware that Real Water had failed an NSF audit?
full pass-fail from my recollection. They give you, depending on how severe, I guess, the findings are. But for real water, in my recollection of the different clinics that I went through, we only ever had a few findings that needed to be corrected, corrective action that needed to be done. But I want to say we were always in the 90% percentile of passing, I guess you could say.
And that audit is required by one of the vendors that real water sold to.
Correct.
All right, I want to comment on two things here. One, they were doing audits. The audits, those aren't going to find hydrazine either. We talked a lot about asset and whether or not that was properly done. No one would find hydrazine either. We freely confess that. They had no idea hydrazine was in the water and it shouldn't have been there. The second thing I want to talk about is Blaine Jones and his own personal injury. As you recall, Mr. Jones testified via video that he wouldn't go through this if you paid him $10 million. He also testified that he wouldn't wish this on his own worst enemy. So if you believe the plaintiffs about the $10 million as a yardstick, you should also believe he wouldn't wish this on his own worst enemy. And that, I think, does go to the reprehensibility or lack thereof of this conduct. He didn't know there was hydrazine in the water. Brent Jones didn't know there was hydrazine in the water. Should they have known hydrazine in the water? That's for you to decide. Does it rise to the level of recklessness and conscious disregard? Again, that's for you to decide. But I think in trying to decide that, you should look at, or you should hear the testimony of the gentleman from Eurofins Laboratories, the laboratory that found the hydrazine. So I think that's the next slide.
And I think that you touched on this one in response to Mr. Kemp's last question, or second to last question, but as far as you're aware, is hydrazine an analyte that is typically tested for in standard bottled water testing?
To my knowledge, no, it is not.
And is hydrazine something that's tested for in any sort of standard water testing that you're aware of, such as municipal water or anything like that?
To my knowledge, no, it is not.
And in fact, you described that Eurofins had to develop a special protocol to even test for hydrazine?
Yes, that is correct.
All right, so what I want to do now is I want to leave you with the last piece of evidence that you have heard. Just want to remind you of that evidence. And I want to play a short piece of Brent Jones' testimony as to what he knew and when did he know it.
All right, did you do any investigation into what went wrong when people got sick? First of all, let me do this. Are you aware of an association between consuming real water 5-gallon jugs in the fall of 2020 and liver injuries?
So I'll just, so we can cut to the chase, I'll answer, what you're asking me. And if it isn't, you can get me to clarify. We had no idea that I had no idea that our water was causing problems. My own son Blaine got very sick, and at the same time, we didn't stop drinking raw water. We didn't have any idea that it was associated with raw water whatsoever. I mean, he got sick himself, and if we would have thought it was raw water, we would have done something. At that time, we didn't, because we didn't know there was any association whatsoever with real water. So no, I did not think that there was any problem with real water in October or November of 2020. I was completely blindsided when it happened in March.
And that's March of 2021. Ladies and gentlemen of the jury, I want to thank the plaintiff parents in particular for testifying and providing their testimony to you, Mr. Tagano as well, and all of the injured parties to the water. I want to thank you, the jury, for listening and for hearing these difficult stories, or not stories, that's the wrong word, this difficult testimony as to what they went through. I want to thank the court and the staff, and I want to thank the plaintiff attorneys as well as the attorneys on the real water team, Mr. Kaufman and Mr. Freeman. Again, thank you very much. Oh, and Mr. Zamora, most importantly, who has been running the show for us and following when I keep changing the script based on what we hear. Again, Thank you very much. We really appreciate your service.
Next, John?
Yes, thank you.
Yes, indeed.
Give me the car keys.
You know, that's funny you should mention that. Thanks. Thank you, sir. Ladies and gentlemen, we're at the end, or virtually the end. I'll try to be brief, or as brief as I can. I got chuckles over there. But I'm gonna jump around a little bit. And it's only because I want to respond to what Mr. Odou has said before I get into some of the things that perhaps Mr. Odou didn't consider. First, I want you to listen to what Real Water's own expert said. To me, this testimony by itself, without any additions, without any seasoning, tells us why punitive damages are appropriate. Shane, can you play Dr. Olson's testimony from, I believe it was Monday, page 153, lines 23 through page 155, line 15. These are the comments from Dr. Olson prior to the comments that, or the testimony that Mr. Kemp played during his closing.
Yeah, Shane, can I have, let's fast forward and let's add another 15 complaints onto this tree, okay? Shane, can I have the October 15th? Ma'am, this is a document that Real Water gave to the FDA in answering questions. So here we are on October 15th. They had numerous complaints by customers. And you can read as well as I can, 25 to 30 calls. This is in addition to those 15 I had on the complaint tree. So you think at this point in time, Real Water should have done some non-targeted GCMS testing, right?
So let me first state that again, this review of the complaints and the information provided therein is beyond the scope of my engagement. So I have not reviewed all of this information beforehand. But looking at what you present on the screen, Mr. Kemp, some form of testing was likely appropriate.
Stop.
If that
We'll get right back to it, Shane, so hold steady. The last thing we heard Mr. Odou say, the very last thing, and I found it surprising that he would end with this, is that Brent Jones said that he did not, first he said, we did not as Real Water, but then he went back and said, I did not know of any of these complaints. Now, we have a statement to the FDA, the Department of the United States government, from his son, Vice President Blaine Jones, saying he knew of 25 to 30 complaints. Someone's not telling the truth. They knew back in October of 2020 that people were getting sick. And then Mr. Odou says, and asked this jury to accept, that they didn't know it was hydrazine. Their own expert just said, it doesn't matter if it's hydrazine, you do a test. You try to figure out why someone is getting sick or people are getting sick. That's corporately irresponsible to not do anything. Keep playing.
that is non-targeted testing, it may have come to that point. There's typically I'll call it a due course of action, at least in my experience as an environmental consultant, in someone that follows due process. And it's similar to how the FDA laid out their testing. They didn't.
Similar to how the FDA did their testing. And what did the FDA do? GCMS, non-targeted testing. And found it, first time. That's what they should have done. Their own expert has now admitted on the record before you that they should have done something. And they chose to do nothing. The other thing I want to remind you of, and I'm gonna play this in a little bit. Mr. Odou also just said that they had no notice of any problems in October or November of 2020. Well, Mr. Anthony Randolph testified that in October and November, he went to Blaine and said, Blaine, you got sick. My nephew got sick. Other people I know about got sick. It's got to be the water. That's what he said, verbatim. It's got to be the water, or it is the water. So, Brent was not being honest. Someone's not telling the truth. Go right ahead, Shane.
Sorry, Mr. Parker, I took that down. What part did you want to play?
I want to start where I left. I was on a roll, Shane. I don't know what line you're on, but you're on page 154. That I know. Only because I actually have it right here. As a guide.
Yeah, Shane, can I have, let's.
We'll find it, bear with me.
Yeah, Shane, can I have, let's back.
A little further than that. Is that the FDA thing that I think you should pass?
On anything wrong.
Okay, so you agree that on October 15th, they should have started doing some sort of testing, some sort of detailed investigation, correct?
I would agree with that statement, yes, that the investigation,
Okay,
my opinion, should have been.
and the last question, how about a recall? They should have done that on October 15th also?
Based on their findings and that evidence, they should have likely consulted with, the FDA and or the state, or the health department in Nevada, and, notify them that's typically the procedure, and then discuss, the level of, potential recall of the product and what that would look like. I mean, that would be my recommendation if I had been consulting them.
So,
Yes.
All right. She admits they should have got with the FDA, should have considered getting consulted for purposes of a recall, should have done some testing and did an investigation. They did nothing. None of those things. Again, a conscious disregard for the public safety. Textbook in terms of why punitives are necessary in this case. The other thing that Mr. Odou said, that for some reason he believes this supports his client's position and why he believes punitives should not be awarded. He said because Blaine Jones continued drinking real water after he got sick. I want you guys to think about this for a second, ladies and gentlemen. People drink and drive. Shouldn't do it. And they put themselves at risk when they do so. Does that give them a right to put the rest of the public at risk when they get on the road having had drinks? Just because you're crazy enough to do it to yourself and risk your own safety, does that give you a right to risk everyone else's safety? The innocent people on the road, or in this case, the innocent people buying your water believing it's safe, not knowing that 25 to 30 complaints have been received? Does that give them that right? Just because Blaine wanted to drink water that made him sick, he shouldn't put the children through it. He shouldn't put these parents through it. He shouldn't put Mr. Tagano through that, or anybody else. That doesn't support their position. It shows just how far they want to distance themselves from accountability. That's what that shows. It doesn't support not awarding punitive damages. And let me say this as well. I think this is something I've learned in trying cases where punitive damages are an issue. I don't want the jury to believe that you have to go through another 3 weeks but if there is a punitive damage phase. That typically lasts no more than an hour and a half. You may have one or two witnesses at the most. Typically, you deliberate. If you say yes to punitive damages, we come right back in, we argue an hour and a half, typically you're done, and then you deliberate over the amount. That's it. So you don't have to go through 2 or 3 weeks of trial again. It's a very short process. So I just want everyone to know that up front. This whole point of we didn't know hydrazine, all of those things would have been accounted for had they done what was required to be done. And that is test, investigate. This point that our expert, Dr. Hudson, didn't do some research on Ms. Doran or Mr. Fisher, that is such a weird position to take. Ms. Doran was trying to help Real Water do better. So I guess Real Water would suggest that our expert should go and ask Ms. Doran for all her medical records so he could figure out every time she had diarrhea. That's what Real Water is suggesting to you. It makes no sense. She knew the difference between her getting sick before drinking Real Water and then drinking Real Water. Because not only did she get sick, her pets got sick, her family got sick. None of those arguments support not awarding punitive damages in this case. And it was curious that Mr. Odou stayed way away from the recall. There's a reason for that. What he did say that I found compelling is that he said that Real Water accepts the testimony and the medical opinions of Dr. Hudson and Dr. Dadnow. If that's the case, then you're accepting the fact that all of these plaintiffs have suffered permanent damage and entitled to further future care, be it neuropsychology or medical monitoring, all of it. Now let's discuss why, or additionally why punitive damages are appropriate. Let's take a look at slide 2, Shane. You remember these dates I talked about in my opening? In preparing for today, ladies and gentlemen, I noticed that plaintiff's initial complaint was filed March 16, 2021. The Real Water recall was what? The day after. I submit to you that was no coincidence. That's how much effort goes into holding a company responsible. Let me have you take a look at the Establishment Inspection Report from the FDA. This is a document that we discussed during opening. It's a document I discussed with some of the witnesses here. I want you to see the first page because, again, I want you to see the date, March 22nd, 2021, an end date. This is one of Real Water's locations in Mesa, Arizona. Go to the next page, please. According to Mr. Brett Jones, president, the firm was established in 1998 or 1999 under the name Affinity Lifestyles. You've heard this. The firm changed the name of their business to, go to the next page, Real Water on 1/1/2018 per the Wyoming Secretary of State. The firm was domesticated in the state of Wyoming. The firm was previously located at West Desert Inn. The firm split in September 2020 and opened the Mesa facility. Per the Arizona Corporation Commission, the firm filed a foreign corporation in the state of Arizona on September 10, 2020. The firm has a parent company, which is a holding company named AffinityLifestyle.com. The firm has a second manufacturing facility at 1180 Center Point Drive, Henderson, Nevada. Complicated company. Next, please. Mr. Lawrence Brown is the production manager at this location. And this is what he said. This is evidence. This is not my words, not Mr. Odou's words. According to Mr. Brown, the firm does not provide training on food hygiene and food safety to employees, and therefore do not maintain records of training. Now, there was a question by the jury earlier on about training. Here is the answer. Mr. Brown also stated he did not have any knowledge of Food Safety Modernization Act, specifically 21 CFR 117, current good manufacturing practice, hazard analysis and risk-based preventative controls from human food regulation. As such, we determined, this is the FDA, determined the facility does not have anyone that has completed training in preventative controls or is otherwise qualified through job experience to develop and apply food safety system that would be in compliance with regulatory requirements. Mr. Brown had no knowledge of the regulatory requirements outlined in 21 CFR 129, processing, bottling, bottled drinking water. Next slide, please. This is the FDA explaining to Mrs. Brown that under the bottled water regulation, gives the site, the firm was also responsible for taking and analyzing bottled drinking water for bacteriological testing, specifically coliforms, at least once a week in chemical, physical, and radiological tests at least annually. And we were not provided documents showing the sampling or the testing was done. So you heard all of this about all the testing we've done, all the testing we've done. They couldn't provide it to the FDA. Next, please. The firm does not have an individual trained in food safety preventative controls was discussed. So when we heard all this back and forth about the dates of Patricia Converse and Desatel and all of this stuff, this is where the rubber meets the road. This is when you're dealing with the federal government and they're indicating, this is not the plaintiffs again, not our experts, that they simply don't have someone. Next page. Now this is the establishment inspection report from the Henderson location. First one was the Mesa, Arizona. This is the Henderson. Started 3/16/21 through 4/7/21. Next page. The walkthrough. This is something you're going to find very interesting because Mr. Kemp laid out how this water is created. You will see from this document that Blaine Jones wanted to keep this whole electrifying using the titanium tubes that he got from the Russian couple a secret. And you'll see this in this document. It says the water is filtered with reverse osmosis and a concentrated mixture of alkalizing chemicals is added to bring the water to the appropriate pH of 9. Now you don't see anything about the electrifying or electrification of the platinum, of the titanium tubes here. But keep looking. You'll see in the next couple of pages. Water passes through the UV filter and is in the bottle washing and filling. 2 environmental health specialists, representatives from the Southern Valley Health District, participated in the inspection, and the Center for Disease Control toxicologists observed day 1 of the inspections. Records were requested. This is what I want you to pay particular attention to. When you talk about corporate responsibility and accountability, I want you to look at how many ways Real Water tried to not cooperate with the FDA. First, records were requested on the first day of the inspection, 3/16/21, but not immediately provided. By the second day of inspection, the Vice President, Blaine Jones, said that all records requested would have to go through his attorney. So he's lawyering up as opposed to cooperating. Next page. Now these are the 9 issues we found. I'm not going to spend your time going back over them, but we went through this with the experts here. All of these violations were found by the FDA. Next. Management was advised that the FDA considers the firm's proprietary E2 alkaline mineral concentrate to be adulterated. I talked to you about this in open. And if you keep reading, it says, further explain that because the E2 alkaline mineral concentrate that's produced in Henderson is a common ingredient to all Real Water brand bottled water products at all manufacturing locations, that all Real Water brand bottled water is considered adulterated under the FD&C Act. Management was advised of FDA legal options to protect public health. Again, the FDA is trying to look out for public health. Suspension of registration, temporary restraining order, and injunction. Next slide. This is a definition of adulteration. I showed it to you in the opening. But the main point about it is they were unable to produce it under insanitary conditions. And it's because they found the product to be not only defective, unsafe, but filthy. Next slide. Now here goes another way that Blaine is trying to not cooperate with the FDA. Mr. Jones is of course asked to come to an inspection. So it says here, an inspection attempt was made on 3/18. Remember, this started on 3/16. But the Vice President, Blaine Jones, did not arrive as previously scheduled at 12 o'clock noon, and the facility doors were locked, so no facility inspection was conducted that day. Now, he's not trying to figure this out. He's not even trying to cooperate with the FDA. He's trying to be an obstructionist. That's what he's doing. Next. As of 3/15/21, CORE reported, and I spoke to you about CORE earlier, that there were 5 cases of acute liver failure with unknown etiology, ranging, the onset dates ranging from 11/8/20 through 11/29/20. And we know that several of the plaintiffs fall within that period. And it speaks about these bottled waters being delivered to the homes prior to illness onset, again proving the relationship between real water and their injuries. Next slide. This is where we talk about the 20 to 30 customer complaints between October 15th and November 15, 2020. And it says, the firm legal counsel provided us with a statement that between those dates, manager Anthony Brown received this number of complaints. So now either Mr. Randolph is lying, Mr. Anthony Brown is lying, or Mr. Brent Jones is lying. Because we have 2 people affiliated with Real Water saying they knew of these complaints. And we knew Blaine Jones was sick too. And Brent just told you that he didn't know anything about it. It reads on. Mr. Brown stated that 7 to 8 of these complaining customers also reported vomiting. The legal counsel also provided an email copy dated 11/11/20 from a customer reporting that their family became sick after consuming the firm's water, and copies of emails between the firm's employees dated 11/28/2020, documenting to them messages from customers complaining that water makes them sick. This is something else that you know was important to them, because now it's affecting their business, but they're still not saying anything. On 4/7/2021, Anthony Brown provided copies of 5-gallon delivery account terminations listing for Nevada, California, and Arizona, in which customers claimed medical reasons for canceling the firm's alkaline water deliveries. How can you believe Brent when they're getting terminations, 25 to 30 customer complaints, his son gets sick, Anthony Randolph tells him recall, 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 and Anthony Brown's aware of it. Perhaps that's why he said he changed from we didn't know to I didn't know, an attempt to skirt responsibility. Further, it says Nevada delivery area medical cause terminations listings show a total of 7 account terminations in the year 2019, 7 account terminations between 1/1/20 and 9/30/2020, and 23 terminations between 10/1/20 and 3/16/21. And he says he knew nothing about this in October and November. That's 30 account terminations right there. Mr. Blaine Jones stated the firm received numerous customer complaints around November, reporting an off taste and nausea. Again, Mr. Odou just said, Brent didn't know anything about this in October and November. Someone did. Several people did. And ultimately reported it to the FDA. Next slide, please. Now, these are the refusals I was speaking about. This is the FDA documenting every time Blaine Jones and Real Water failed to cooperate or refused to cooperate. So it says here, the highlighted portion says, the second section is where mixing and concentrate takes place. The reason I brought this up is because Mr. Kemp, during his opening, stole my thunder. Mr. Kemp said they had the secret room for the concentrate. Well, they kept it secret from the FDA. This is what it says. The second section is where the mixing of concentrate takes place. During the initial walkthrough, Blaine Jones told us the processing area consisted only of the main building. So he gave him some kind of layout. He did not tell us that the adjacent section was a part of the production And this section was not included in the diagram provided to the Southern Valley Health District in the company's permit application, although it is included in the lease agreement provided. Simply telling a lie to the FDA because he didn't want to show them the concentrate room. Next slide. On the second day of the inspection, remember he canceled on the 18th, started on the 16th. We met Lane Jones at 1:00 p.m. to accommodate his schedule. Maybe. Lane Jones refused to answer questions about the bottled water production. When you have this amount of people getting sick, you got the CDC involved, the FDA involved, the Southern Nevada Health District, and you're refusing to ask questions? And then Mr. Odou can get up and say, we didn't know there was hydrazine. You're doing everything you can to prevent the government or your own company from figuring out what's causing these injuries. He says, and he stated all records requested have to go through his attorney, Craig Mueller. N.E. Jarity is one of the FDA inspectors. Asked Blaine Jones if he was refusing inspection. And Blaine Jones said he would allow sampling but would not answer any of our questions. That's someone who's begging for punitive damages. Because he could care less. This company could care less about public health and safety. We planned a return to complete our inspection on 3/18/21. We scheduled a new appointment with Blaine Jones to accommodate his personal schedule again. An inspection attempt was made, but Blaine Jones did not arrive as previously scheduled at 12 noon. The facility doors were locked, so no facility inspection was conducted on that day. Mr. Gary called Mr. Jones and left a message on his answering system, informing Mr. Jones that we were at the facility for the pre-scheduled meeting and requesting a return call. No return call was received from Mr. Jones. Next slide. Mr. Gary requested processing records for the approximately 5-gallon bottles of alkaline water. Mr. Jones refused, again, these requested processing records, stating that the processing records were lost in the move from Las Vegas to Henderson. How many ways can you find to obstruct justice or to prevent someone from being able to figure out what's going on and preventing further public injuries? I don't know if this takes the record. On 3/19/21, Mr. Garrity and I returned to the facility at 2:00 p.m. to meet Blaine Jones, scheduled through his attorney. Mr. Jones said he would not answer any of our questions, but did show us the section of the building, finally, where the real water concentrate is mixed. That's what it took to finally get access to that concentrate room. Next slide. Mr. Jones declined to provide any of the requested documents to the inspection team, so he's not giving documents, he's not answering questions. As justification for his denial, Mr. Jones claimed 2 excuses. The firm's chemical supplier would not be able to provide any documents until Monday, and the firm's legal counsel still needs to review all of the requested documents before they are released to the FDA.
Yeah, we approach. Sure.
Thank you, Mr. President. Oh, you're welcome. You're welcome. All right, let's put that back up. All right. So these are the excuses he's using at this point to try to prevent the FDA from getting his information. When you cannot argue that punitive damages are not required when you see this type of evidence. Because not only is this a conscious disregard, this is a blatant refusal to consider the public health. That's what you see here. Finally, let's go to the next slide, please. This is the first time that Mr. Jones admits to the FDA that they're ionizing the water through these titanium tubes. And I said that earlier, you finally see. Mr. Jones said the firm's ionizing process was intellectual property purchased by his father, and he did not want to reveal the procedure in front of Mr. Brown. But wanted Mr. Brown present as a witness. I explained to Mr. Jones that any trade secret information provided to the FDA by his company was not releasable to the public and would be redacted from his report if any FOIA requests were made. Mr. Jones addressed Mr. Brown and said he was going to have to sign a disclosure agreement and told him he wanted wanted Anthony to be present with him as a witness. They didn't even want their own employees to know how this E2 concentrate was made. Didn't want the FDA to know. So when you have a proprietary intellectual property they're trying to protect, and you're preventing the federal government from determining how this product could be causing these illnesses and injuries, how could that not be determined to be a conscious disregard of public safety? Because you can't figure it out. The FDA had to do testing because they wouldn't cooperate with the FDA. So when Real Water gets up and says, we just didn't know, they did everything to make sure the FDA didn't know. We had to hire the best in the country to figure it out, and they've taken no responsibility. Could you show me one more time the verdict form? All completely filled out? Ladies and gentlemen, this is how we believe the verdict form should be filled out. And I would agree with Mr. Odou on this point. The determinations on the amounts are yours to be made, within your discretion. You're the finders of fact, you determine the amount. But what we did, and what I believe is the appropriate thing to do, is we gave you suggestions using the only evidence we have right now, which is Mr. Blaine's testimony, since he's been through it. I have not. Mr. Kemp hasn't. Mr. Odou has not. The only person who's testified has been through it, other than our plaintiffs, is Mr. Blaine Jones. And he said $10 million. And we put it less than that. We're not trying to give you some high number so you can find some middle ground. We thought we gave you a very reasonable number that reflects the injuries suffered by our clients in the past and anticipated in the future. The other thing I want to point out to you, ladies and gentlemen, is that Mr. Odou has put in front of you all of the medical bills, the amounts. And then he says, well, we're just a consideration. We're not saying that the medical bills, there's some formula you should use. The medical bills don't reflect the suffering. I'll give you an example. It doesn't cost a lot to get a leg amputated. The pain that goes along with the leg amputation is extreme. The way it changes your life forever, be it a crutch, be it a prosthesis, is forever. The medical bills could be less than $20,000. You tell me that $20,000 is representative of the suffering of going on without that leg? Mr. Odou is using numbers to suggest that that is medical bills to suggest that that's what the pain and suffering amounts to. Mr. Blaine Jones wouldn't take $10 million to go through it, and yet he's suggesting that they should take 500 or 50. I don't see how that makes any sense. And it certainly doesn't make sense based on the evidence we have. Ladies and gentlemen, I want to end with something that I read last night. Well, I've read it before, but I read it again last night. I have one life and one chance to make it count for something. My faith demands that I do whatever I can, wherever I am, whenever I can, for as long as I can with whatever I have to try to make a difference. When I met you, I said this case will give you an opportunity to make a difference. A difference in these plaintiff lives, a difference in this community. I didn't make that passage up. I came from Jimmy Carter, who's not doing very well right now, as we know. But it makes sense. We've given you the evidence to make a difference, and we ask that you do. Thank you very much for your time and your patience. I really appreciate it. We all do. on behalf of the plaintiff as well as the defendant. And I would be remiss if I didn't say thank you to the entire court staff for having entertained and handled this case for the last 3 weeks. We really appreciate it. Thank you very much.
Will the clerk please swear in Ms. Rivera and Ms.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them nor speak to them yourself unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God.
I do. Thank you. So ladies and gentlemen of the jury, I'll tell you now our alternates in this trial are juror number 10, juror number 9, and juror number 12, Mr. You are not excused from jury service, but you are to follow Ms. Rivera. Now, we still need you in case something, heaven forbid, something happens, but you'll go with her and she'll tell you to make sure you know what you're going to do, but you will not be participating in deliberation, so you're excused to follow Ms. Rivera.
Bring all your stuff with you.
Including your notes. Please rise for the jury.
Please be seated. So, the rest of you are our jurors who will be deliberating, although Tom is going to break for the day. If you all are able to, you can come back tomorrow to start at 10 a.m. If not, then 11 a.m. is fine.
What time did you say?
10 a.m. if everybody's able to do that. If not, 11 is fine. Once you return tomorrow, then you can begin deliberating. But for now, admonishment, hopefully one last time. During this recess, you're admonished not to talk or converse amongst yourselves or with anyone else on any subject connected with this trial. Do not read, watch, or listen to any report of or commentary in the trial or any person connected with this trial by any medium of information, including without limitation to social media, text, newspapers, television, internet, radio. Do not visit the scene of any events mentioned during the trial. Do not undertake any investigation. Do not do any posted communications on any social networking sites. Do not do any independent research, including internet searches. Do not form or express any opinion on any subject connected with the trial until the case is finally submitted to you. We'll see you back in the jury room, actually, not in here, but in the jury room at 10 if you're all able to, if not, 11.
Please rise for the jury.
This just popped into my mind, and maybe that we took care of this at some point, and I just don't remember. But in terms of depositions being published, Anthony and Randall, is that right? Just that one, obviously a lot more played. Does anybody want any depots published that haven't been? I can't, and maybe we already talked about
the Randolph's fine with that.
Yeah, that's fine with us. There's some things that we need to collect from the court to free up the space. We go over that real quick. I think there are some binders and the depositions. We would wait for a verdict, or do we need to get them out of here now? Would you like us to get them out of here now? Whatever is convenient for the court.
I was gonna say, if you can order back everything that you haven't used and hasn't been admitted, and then you guys can coordinate having people come pick them up.
It doesn't need to be now, but yeah, so the court orders that any exhibits that we have that have not been admitted, you return any deposition transcripts that have not been published be returned to parties. Is that enough on your, for me to say that?
Yes. Don't forget to bring a laptop if you don't already have one.
We do have a clean laptop that we could provide, so it's ready for tomorrow morning. The only other thing is, just to be clear on the exhibit list of the admitted exhibits, is that something that you have or something that you'll need us to provide?
I have that, so that'll go, they'll have that.
Okay, great. And then are there any exhibits that you have that we haven't provided to you electronically or in paper copy form?
I have everything.
Okay, great, thank you.
That does, so along the lines of the laptop, who's responsible for checking, making sure all the admitted exhibits are on there and nothing else is? Who's handling that? Is that, that's not on our,
So I have the drive that I put all of the admitted exhibits, so they're not gonna have anything else.
Okay, perfect.
And on that note, Your Honor, Mr. Zamora has looked at the laptop, so it's been vetted by both sides.
Okay, okay. Thank you.
I mean, I trust you, Shane.
Can we take that now? Yeah.
Yeah, that's
do
fine.
that. Let's take that.
I will accept that representation on the record.
Oh, thank you. Did they say 10's okay?
10 o'clock is fine.
Okay.
Here at 10.
Perfect. So, you never know how long it's gonna take. And they give a little more detail probably than I need to, but sometimes we learn things the hard way. So, be close by. Close by does not mean waiting, for example, in Summerlin on an afternoon for the verdict. Close by means, you don't have to be in the courthouse, but, within 5 to 10 minutes from the courthouse, in case they come, for example, like, we may not get a verdict quickly, but we may very well get a question quickly. What I do not enjoy is having to wait for attorneys to take a half an hour more to get here. And probably preach in the choir, but that's happened before. Anything else or any questions?
Does the court have the cell phone numbers for one person from each side to use, or do we need to provide that?
Can you provide that?
Amanda has those.
She already has them?
Yeah, we did that, day one.
So who's she supposed to call first? On defense side, who should she call?
She can call me and I'll call everybody else.
Okay.
Sure,
I have some. Okay. I have a question. I have Mr. Odou, 702-498-2134.
Correct.
And then I have Mr. Pepperman. Mr. President, 281-1002.
Yep.
There you go.
I'll need to rule on the punitive damages, the company one, right?
I thought you did, maybe I'm mistaken.
I thought you said you were gonna go with plaintiff's instruction yesterday.
Oh, there was another one though, it's a small company.
I said no on that one, and yes on that one, but no on that.
It didn't matter, you stayed awake.
I don't think I ruled on it yet, so I'll have to do that, I'm not prepared to do that right now. Anything else?
No, Your Honor, just again, thank you to you and your staff for everything. It's a very well run courtroom, we appreciate it.
It's not over yet.
So far.
All right.
Thank you, Your Honor.
Thank you.
Thank you all. See you probably tomorrow.